In this video we will discuss the importance of a power of attorney document. A power of attorney document is a legal agreement that gives another person the authority to make decisions on your behalf. If you are unable to make decisions for yourself, this document allows someone else to represent you. This is important because it ensures that your wishes are followed when an emergency arises or if you become incapacitated. Let's explore how a power of attorney differs from other types of legal documents and why they can be so important in our daily lives. What is a POA document? A power of attorney document allows you to appoint someone else as your agent. That person is then authorized to make decisions on your behalf. This can be especially helpful in the event that you are unable to make important decisions for yourself, such as when you become incapacitated due to an accident or illness. In such circumstances, if you do not have a POA in place and available, it could take weeks for decisions that need immediate action to be made on your behalf. There are two types of documents commonly referred to as power of attorney documents. One type grants decision-making authority only during incapacity, the other gives decision-making authority while the principal remains competent. A power of attorney for healthcare decisions. This document gives the person you grant authority to the ability to make medical and end-of-life decisions on your behalf if you are unable to do so yourself. This usually occurs when you become incapacitated by an accident or illness, can no longer express your wishes, and have not executed a living will or advance directive. A power of attorney document established during healthy times. Most people do not want another individual to make important decisions about their life without being consulted first. A single decision could be costly, as in the case of signing a contract that cannot later be broken due to conditions surrounding the deal. A power of attorney document that gives decision-making authority only during the incapacity of the principal is a good option for some people. This type of power of attorney allows someone else to make decisions on your behalf when you can no longer do so yourself, but it does not give that individual authority over your life while competent. A power of attorney for property and finances. A person with this document has the ability to manage money or other property on another's behalf if necessary. The POA grants limited authority, which usually involves paying bills, collecting debts, and continuing normal business operations without interruption. It does not allow someone to sell your property or enter into more significant financial agreements without consulting you first. Also, it will expire once you recover from the incapacity. Why should you have a power of attorney document? You don't want your family or loved ones to be embroiled in an expensive and time-consuming legal process that concerning your health care, business decisions, or financial issues when they are grieving the loss of a loved one. A POA gives your designated agent the responsibility and authority to help protect you during these difficult times. It can also prevent unwanted legal battles among your family members over making important decisions about your life, while you remain competent, but unable to execute documents on your own that express what you desire done in such circumstances. More importantly, it ensures that someone is authorized to act on your behalf at any time. Thus, if something happens where you become incapacitated and unable to make your own decisions, a POA document will be there so an agent can be authorized to act on your behalf. How should you go about selecting someone to serve as your agent? It is important that you trust the person and share with him or her all of the relevant information concerning your health history, financial affairs, and business interests. This individual must also be willing and available to take responsibility for making decisions that affect you if necessary. For instance, he or she might have to step in at any time when needed. Your designated agent should have access to confidential medical records and other documentation concerning these matters if they are involved in decision-making capacity. The process of establishing a power of attorney document is relatively simple. You can contact a specialist such as a lawyer to help you. A POA document is executed by the principal, and it must be written in a legally recognized format to ensure the agent's authority can be recognized by healthcare professionals, financial institutions, businesses, and government agencies if necessary. Your designated agent might not know about your specific desires concerning certain matters when they are unable to make decisions on your behalf for one reason or another. In these cases, he or she will consult with either you or an attorney, if possible, before committing to any particular course of action on your behalf. Of course, this person is also obligated to follow any instructions that you provided beforehand while still competent enough to express them. Who should have a power of attorney? Anyone who might find themselves unable to make decisions in the future and has someone they can trust to act on their behalf. This is especially important for anyone with a young family or dependent children, as it will prevent long-term legal battles concerning child custody and asset distribution if things go wrong. In conclusion, instructing somebody else to take responsibility for your life, when you cannot do so yourself, provides a tremendous sense of comfort and security. By executing a power of attorney document, you ensure that someone can take responsibility for the important decisions affecting your future. It is also a simple process that is not expensive to have done properly. Contact us at Janetti & Krause for your estate planning needs today.